Hi everyone, my name is Michael Wurster. I'm an attorney here at Zanck, Coen, Wright, and Saladin in Crystal Lake. I specialize mostly in family law, even though I do general law. And today I'd like to talk to you about a couple of updates and developments in family law in Illinois. The first major issue I'd like to talk about is, starting in 2015, there was a change in the maintenance law. And it's a big issue for most couples who get divorced. How are you going to live post separating from your spouse? Stereotypically, that normally has a much larger impact on the wives. More and more, though, men and women are making equal amounts of money. More and more women are getting into the workforce. Men are working less and less, which means that we're noticing more of an equalization of women starting to pay maintenance to their husbands. But it is stereotypically a little bit more that husbands pay to their wives. And before 2015 and 2016-17, and it's continuing to have modifications in maintenance, it was kind of wide open. You had to look at the standard of living during the marriage, looked at certain factors and what the party's income was, and then you try to argue what duration should be and how much maintenance should be. After the modifications, the court made it a lot simpler. You have a formula for any parties that make combined gross income of $250,000 or less. In 2018, June 1st, it's possibly going to go up to $500,000 gross income or less. But it simplifies and makes it a lot clearer, not only the elements of whether you determine to be a candidate for maintenance, but to the duration of maintenance if you are determined to be a candidate and the amount. So what you have to do when you're requesting maintenance is first have the court determine that you're actually a candidate for maintenance. And there's a large list of factors in the statute that the court's going to look at. How long have the parties been married? What were the spouse's education and employment opportunities during the marriage? What sacrifices has the spouse who's requested maintenance? Normally they're going to look at has one spouse basically given up employment or educational opportunities for domestic responsibilities, which normally boil down to taking care of the children and taking care of the house. So stereotypical situation is there's a wife who, the party's been married for 20 years, they got married straight out of undergrad. She essentially didn't get a job or maybe worked for a year or two, and then they had kids. The parties agreed that she'd stay home. She's taking care of the kids the entire time during the marriage. Maybe she went back to work after the kids went off to school, but she's always made $10 to $15 an hour, working part-time. So maybe she makes between $15,000 to $30,000 a year. Not quite a lot of money. Whereas the husband during that time, maybe he's had 20 years of building his work, his employment opportunities, his skills. Maybe he's got a master's. And he continued to further his education and his ability to earn income while the wife was at home. And she's now stuck essentially at the age of maybe 40, 50, 60 years old with an inability to really increase her earning potential. So now maybe you have a husband who's making $100,000 a year and a wife who's making $30,000. And so if that's the case, while we can never guarantee whether a judge will grant maintenance or not, there's a decent chance that a judge will grant you maintenance because there's a large disparity of income, and based on those factors, more than likely you're going to need to have at least a small period of time to rehabilitate yourself and start to earn potential. So for this circumstance, let's just assume the judge finds that you're a candidate, which is step one. If you're deemed to not be a candidate, you don't move on, you just don't get maintenance. And that is essentially you're barred from maintenance forever if you determine to not be a candidate for maintenance from the get-go. What happens then is they're going to look at the duration of the marriage, right? So based on the duration of the marriage, there's a percentage of time that you'll get for the maintenance payments. And what I mean by that is they've broken it up into 5 categories of maintenance duration. So if you're married from 0 to 5 years, essentially, which when I say essentially, that's because it's really from 0 years to 4 years, 365 days. It's really 0 up to but less than 5. And then 5 years, greater than 5 years, but less than 10 years. Greater than 10 years, less than 15. Greater than 15, less than 20, and then 20 and above. So if you're in that 0 to 4 years and 365 days, it's 0.2 duration. So essentially, if your duration is about 4 years, 365 days, we're essentially talking about 5 years. So 0.2 of 5 is 1 year. 20% of 5 is 1. If you actually hit the 5-year marker, so just a change of 1 day, now you're at 0.4, because the 5 to 10 is 0.4, 10 to 15 is 0.6, 15 to 20 is 0.8, and then 20 and above is permanent maintenance or maintenance for the duration of the marriage. And when I say duration of the marriage, what I mean is it's not how long you were legally married. It's actually from the day you were married to the day the petition for dissolution was filed. And that's an important distinction, because if you file your petition, say 9.5 years into the marriage, but then the divorce goes on for another 2 years, you don't get bumped up in that 10 to 15 range of 0.6. You're at the 9.5, you're at 0.4 of 9.5 years. And when I talk about 20 years or greater, it is really permanent maintenance. And what I mean by that is it's an indefinite period. There's no cutoff point. So the judge can just say it's permanent in duration until further court order. Otherwise, say you're married for 26 years, the judge can say you're entitled to maintenance for 26 years, the duration of the marriage. Again, from the date you were married to the date the petition was filed, whatever that duration is. After that, though, the next question is how much you're going to get paid. And they've put a formula in which it's pretty straightforward. It's 30% of the payor's income minus 20% of the payee's income, with a cap of 40% of the combined parties' gross income. When I say income, I meant to say gross income, not net. So it's before any taxes are taken out. It should be anything that either party makes during the year. And so with that being the case, it should be somewhat cut and dry unless you do have a party whose gross income fluctuates quite a bit. Maybe they're self-employed, so it's going to be a question of what their gross income actually is. It might not be straightforward if they are getting paid a salary and a W-2. If that's the case, it should be very straightforward. But otherwise, if you're a candidate based on the elements, they're going to decide what the duration is based on the date from marriage to the date the petition was filed, and then they're going to calculate the maintenance based on each party's gross income. And that's really one of the major issues that most parties come to us, which is maintenance, and hopefully that gives you a better understanding of where you might fit in if you do decide to get a divorce. Okay, on to our second topic, which is the second largest change, really the most recently, is July 1st, 2017. We've altered child support. It used to be a strict percentage of the payor's income. Now it is what is called as a income share approach. And what we mean by that was under the Illinois Marriage and Dissolution of Marriage Act, it used to be a straight percentage of normally the father's income. And we'll talk about normal situations here. Usually it's the dad paying the wife for the children for the child support. And so in those situations, if there was one child and the dad's net income, so gross minus deductions, was $50,000, he'd pay 20%. So that's $10,000 of his income that he would pay every year. If there was two children, it was 28%, 3, 32, all the way up to 50. Now the legislators decided that was a little unequitable. They wanted to take both parties' income into account. So with the income share approach account, they had the Illinois Department of Family and Health Services come up with tables. And these tables determined that based on the parties' joint gross income minus the standard tax deductions, they come out to net adjusted combined income. So they're going to look at whether it's the ex-wife and the ex-husband, or if they were never married, both the mother and the father's income. They're going to say, okay, so maybe they make $100,000 combined. Well, for looking at the table, with the parties that make $100,000 in net combined income, if you have one child, they have to pay X amount in child support. So maybe that's $10,000. Well, then they also look at the proportional share that each party makes. So with that combined net adjusted income, say one party makes $60,000 and the other party makes $40,000. well, then they're going to have that one party essentially pay 60% of that $10,000 or $6,000. The other party pay 40%, which is $4,000. Now, you're only going to pay if you don't have the child the majority of the time, right? So if the father's making $60,000 out of the $100,000 net combined income, and they have to pay that $6,000, and the mother has the children majority of the time, he does have to pay the $6,000. The mother does not pay the $4,000. That's her portion, but because she has the children, she doesn't have to pay that amount. It's just splitting that $10,000 at a pro rata share. Now, the question becomes, how many overnights does each parent have the children? Because the legislator understands that if the parties are getting closer and closer to having the children overnight and a larger percentage of the time, they are carrying more and more the burden of the daily expenses. So under this statute, once a parent hits over 146 overnights per year, they recalculate the child support. They're going to cross multiply. It's a very specific and complicated formula that we use, which I don't know if we need to get into now. But essentially, it readjusts what the child support payments are going to be, and it will tend to lower the child support payment for the paying party, and that makes sense. If you're say your ex-husband only had him every other weekend, 1 day a week, maybe that's 100 nights per year, but then you start increasing the overnights. He's taking on a larger percentage, a larger portion of the daily cost and cost to have the children there. You should pay less in child support. Same if a mother's having a child over more and more, and they don't have majority of the parenting time. As you get closer to 50% of the parenting time, the child support amount is going to decrease. And especially once you hit the overnight amount of 146, you have to recalculate the child support, and it will decrease. And that's really essentially the major change with child support at this time. It does also really start to move towards a pro rata share for child-related expenses as well. In fact, the statute makes clear you're supposed to use a pro rata share for daycare expenses. But I do think there's some wiggle room there where judges may be moving towards pro rata share expenses for educational expenses, extracurricular expenses, healthcare expenses for both premiums on medical insurance and unreimbursed medical expenses, as well as any other expenses that the parties might agree to. What I mean by pro rata share, again, is if one party is making 80% of the income and the other party is making 20%, maybe that's how you split payment for those expenses. And not all parties are going to move towards that. A lot of people, if they make close to the same income, even if it's not exact, they normally do 50-50. But it is moving towards much more of a pro rata approach, both in child support payments and child-related expenses. Okay, and for our final topic on the changes to the Illinois Marriage and Dissolution of Marriage Act is that there's no such thing as custody or visitation anymore. And so I hear it all the time speaking with potential clients that, well, I want custody or I want a certain amount of visitation. The Act basically did away with those terms. What we have now is parental responsibility, and that's broken down into two categories, which is decision-making and parenting time. And I think there was a lot of confusion before on what custody and visitation was. I hear people all the time say, well, I want custody because I want my kids. Custody was never a determination about who had the children. It was just a kind of a hand-in-hand situation where if the judge had determined that you should be the custodial parent, meaning you should have all this significant decision-making powers, they did that because they felt you were the better party to make those decisions and had your child's best interests in mind, and you're the party who was more likely to make the best choices for your children's best interests. Well, if that's the case, they also probably believe that you're the parent who the children should live with the majority of the time, and that makes sense. So custody was always really about significant decision-making, unless you had residential custody, which would be a determination of technically who did the child live with. And even still now, you might have that designation for enrolling your children in school, even with 50-50 parenting time. You will normally see a designation in the MSA, a marital settlement agreement, as to who's the residential custodian, even though the children are living at the parents' houses equal amount of time, just for any registration papers if you have to put an address down for your child somewhere where they technically live, even though, again, they might be living at both parties' houses on an equal time basis. And visitation, again, is actually the amount of time you have with your children. So when you think about visitation, you're visiting with your kid. How long do you have to visit with your child? And right now, and it has been like this for a while, tends to be one parent gets a majority of the parenting time, and the other parent tends to get every other weekend with one night a week. And when I say one night during the week, it's not an overnight. It tends to be from after school until 7, 8, 9 o'clock at night. Whenever the parties agree, the children have to be home. But it gives that parent time to maybe go grab dinner, do their homework, take them to a practice that night, spend night with them during the week. So there's not such a long break in between their every other weekend. Because that is a long time to not see your child. But it is kind of changing now. With the changes in the law, it's gone from custody to parental decision-making and visitation to parenting time. And it kind of makes sense because custody was always decision-making power anyway, so they just called it decision-making. And visitation was always the amount of time the parents got to spend with the children, so they changed it to parenting time. And the one major difference that does come out of this, though, is with custody before, it tended to be you either had sole custody, where one party made all the decisions for significant decision making, and significant decision making includes education, so where a child goes to school, tutoring, things of that nature, religion, so how they're going to be raised in what religious faith, so Catholic, Lutheran, Hindu, Muslim, Jewish. One parent might have the sole decision making power on that, and that might be a point of contention. Medical decisions. Do they need a surgery? Do they need an elective surgery? Are they going to go to the doctor today? Those are decisions that if one party had it, the other party really had no say. And then extracurriculars, which in today's climate might be a bigger issue with concussions and injuries mounting, where one party might not want their child playing football or ice hockey or soccer, and another party might be completely fine with that. But back before, when it was just strictly custody, it was really either sole or joint, and joint, both parties had equal say on every single one of those categories, right? Education, healthcare, religion, and extracurriculars. After the change, sole still means the same. If one party gets the decision-making for parental decision-making, they don't have to consult the other party. They can make those decisions and move forward. With joint, the parties now have the ability to say, look, we can either split every one of those categories equally. We have to talk with each other and come up to an agreement. Otherwise, we have to go to mediation. Or say one party's a teacher and one party's a doctor. Well, the one party who's a teacher, and they might agree, they should have the sole decision-making power on their educational issues. The doctor might have the sole decision-making power on their medical issues. And those might not be joint, and they'll split the other two remaining issues then. So it gives you a little bit more flexibility on who can make decisions for each category of significant decision-making. Now, when I say significant decision-making, that doesn't mean what they eat when they're at the other parent's house. If they want to go to a friend's house during their weekend off. Things like that. Each parent has the right to make those decisions when their child is with them. When they go to bed, what they eat, as long as it's not harming them, who they're around. And I understand that's a point of contention because parents might conflict with how they want to raise their kids, but those are not significant decision-making issues. The next issue then is parental decision-making. Parenting time, which, again, like I said, for a long time it was always one day a week, every other weekend. Depending on where your case is being handled, some districts, some courts are a little bit more conservative than others. Some courts are starting now from the same exact spot, which is every other weekend, one day a week, and you have to show why it's beneficial and not harmful for the child to move towards a 50-50 parenting time schedule. Other courts are now starting to move from, I'm going to start with 50-50 parenting time. Mom and dad get equal amounts of parenting time, and unless you can show that it's harmful for the child and it's not in their best interest, then we'll move to every other week and one day a week. But if you can't do that, then we should work on 50-50 parenting time, because it is kind of more and more as we go along. There's more and more articles and studies about mothers and fathers having equal amount of parenting time in a child's life and the benefits for that. So there might be a movement over time that instead of this idea that moms are automatically going to get a majority of the parenting time and fathers will get every other weekend, we might be start jumping off from 50-50 parenting time, and unless you can show a good reason for why that won't work, that's how the courts are going to move forward. It's not a guarantee. Some courts are much further along on this. Some are much more staunch on we're still sticking to every other weekend and 1 day a week, but there's a lot more room to have that take place now.